We're going to start with State of Ohio versus Scott Wilson. It's case number 18AP0037. Each of you will have 15 minutes to present your arguments to the court. And we do, I think both of you know this, that we do post the videos on YouTube, so we ask that you keep your voice up and stay by the podium. We try to refrain from using victims' names or children's names, just refer to them by initials. And we have read the briefs and we're prepared to proceed if you are. Let me know if you're going to reserve any time, by the way, counsel, and I'll let you know as you get close.
Thank you, Your Honor. We would reserve 3 minutes for rebuttal.
Now, before I start your time running, you'll see on the TV screen here, we do have the clock which will run.
No pressure.
Huh?
No pressure, right?
Yeah. Well, you're going to see that 15 on the top start counting down.
Yes.
When it gets to 3, I'm going to remind you to stop there. In other words,
Yes.
that's your total time. Some people get confused with that. All right, thank you, and you may proceed.
Thank you, Your Honor. My name is Ben Miller. I'm here on behalf of Mr. Scott Wilson in the matter before the court today. This is a case that involves Mr. Wilson, who was stopped and cited for driving under the influence and operating with a prohibited breath alcohol content. The events occurred on September 24th, 2017. Mr. Wilson was returning home from BG's in Whitman. At the same time, 2 officers from the Wayne County Deputy Sheriff's Office were responding to a call at Miller Residence or Miller Farm regarding a potential prowler. And when they were engaged in that particular call, and the officers were Deputy Broom and Sergeant Ellis, Mr. Wilson drove through that area. And according to the officers, Mr. Wilson was speeding, he went left to center, and he honked his horn. Mr. Wilson testified at hearings on motion to dismiss as well as motion to suppress evidence that he did not engage in that conduct, that he did not violate any traffic laws. During the course of the case, defense counsel, Mr. Wilson's trial counsel, asked for and received a motion to preserve evidence. That motion included a request for all relevant videotapes. And throughout the course of preparing for a hearing on a motion to dismiss, well, it was originally a motion to suppress and also became a motion to dismiss. In discovery, there was a disclosure that Officer Broom had a videotape that could potentially be relevant to this matter. That videotape was never turned over, although I think the record demonstrates clearly that trial counsel repeatedly made attempts to get this particular video, but he was unsuccessful in doing so. And
Were the requests specific?
Well, the first request was a generalized request to preserve all evidence, but it did include a request for videotapes. And obviously, until discovery is done, you're not going to know specific videotapes. When discovery was done in this case, there was a supplement from Deputy Broom in the discovery packet, and that indicated that he had a videotape, an Axon videotape. And then there became direct demands for Deputy Broom's videotape.
And all the video would be body cam video in this case.
Correct. Correct. And there was also videos, and I did argue both of these in the same assignment of error because they're both deal with lost videotapes. Sergeant Ellis, at the hearing that was held on the original motion to dismiss as well as the motion to suppress evidence, it was disclosed that there were more videotapes out there, and the hearing was continued in order to allow the prosecution to determine if there were any other videotapes available and relevant to this. And it turned out Sergeant Ellis, when he went back and checked his account at evidence.com, saw that there were 5 videos, that 4 of them were disclosed to counsel. The 5th one, which arguably would have shown evidence of Mr. Wilson's driving, was not provided. And because both Deputy Broom and Sergeant Ellis categorized these videos as a general video because they associated it not with the stop of Mr. Wilson, but with the prowler report at the Miller residence. So because of the way it was classified, after 30 days, these were automatically destroyed. Is my
What's the
understanding.
basis for your statement that the fifth video would have shown driving? Is there
The
testimony?
basis is because the transcript shows that Sergeant Ellis was looking at the car and testified as to the car. He claims that, well, the body cam showed anything because I was looking over my shoulder and that it was solely, would have been into a cornfield. Our position is that it's kind of self-serving. I mean, he was right there. It would stand to reason that he heard something that startled him enough that he quite possibly could have turned around.
Well, was he out on the road to look for cars coming down the road? What was he doing out in the by the cornfield?
He was looking for a prowler. He was checking the cornfield, and then he heard the car coming. And Deputy Broom was also on the property. He was facing the road. And his testimony was that this would have shown maybe 2 to 3 seconds of video. But it could have been an important 2 to 3 seconds, even if that was all that it showed. Because this is a driving under the influence case, obviously one of the main issues is how was that individual's driving? Did it appear that that person was driving as if under the influence of alcohol? And that was never provided to, in fact, Mr. Wilson or his counsel. The question becomes whether or not this was in fact exculpatory evidence or not. And generally, the rule is that if the state, either by inadvertence or through bad faith, destroys property that would have been material to exculpability or punishment, that would be a due process violation. Normally, the burden is on, in fact, the defendant to demonstrate whether there's material exculpable evidence or not. In this case, the law is clear when there's a request for that the burden shifts to the state to determine whether or not exculpable evidence was destroyed. In this case, there were 2 decisions on the motions to dismiss. The first one dealt with Deputy Broom, and the second one was dealt with Sergeant Ellis. And there was 2 different judges on this. There was a change in judges during the pendency of this case. But both of the decisions, neither one of them assigned who had the burden of demonstrating whether this claimed evidence was materially exculpable or not. And I think the court was required to assign that burden either on Mr. Wilson or the state, and it failed to do so. So the court could send this back and ask that the trial court, in fact, do that. The next issue is if the court finds that there's been a demand to retain certain evidence, which is our position that Mr. Wilson, in fact, did, then the burden becomes on the state of Ohio to show that this was not materially exculpable. And I know that there's a Supreme Court case that is out of a DUI that indicated, well, generally speaking, if you're just dealing with, and this was during the motion to suppress hearing as well as the motion to dismiss, if you're just dealing with what they refer to as potentially useful evidence, and it doesn't go to the substance of the offense, that that you're not dealing with materially exculpable evidence, and if it's just merely useful and the state, rather, Mr. Wilson has requested it, the burden would then be on Mr. Wilson to show that that should have been preserved. But in this case, it's a little bit different than the case that was before this Ohio Supreme Court, because in that particular case, the Ohio Supreme Court noted in its decision that counsel at oral argument basically conceded that the only purpose for that would be to challenge the stop. In this case, I believe that evidence of driving in this case, and I think it's important to note that the officers testified diametrically opposed to what Mr. Wilson testified to. Mr. Wilson said, I didn't commit any traffic violations. the only objective evidence to that, as in similar to State versus Benson, is in fact the evidence that will be contained on the Axon body camera. That would be the objective evidence. And one of the tests that they've said about potentially useful evidence is that it could be used, could be tested, could be potentially useful. But this is the type of evidence that the videotape would speak for itself. And it was the actions of the law enforcement that directly led to this evidence not being, number one, properly classified, and number two, ultimately being destroyed, despite the fact that there were requests for this materials. The second videotape of Sergeant Ellis wasn't even disclosed until during the hearing of the original motion to dismiss and the motion to suppress. That hearing, there was a ruling on the motion to dismiss at that time, and then the motion to suppress was continued, and in the interim, defense counsel filed the second motion to dismiss based upon the failure to disclose Sergeant Ellis's videotape. So it's our position, number one, that the trial judges should have assigned whose burden it was to determine whether or not this evidence was in fact material. And number two, that burden should have been in fact on the state of Ohio, because there was a specific demand for videotapes regarding this matter. It's unfair to require more specificity from a defendant in a case when they're relying on disclosure from the state of Ohio for this information. That disclosure led to the trial counsel's discovery of the original videotape from Detective Broom, and the videotape from Sergeant Ellis that had not been disclosed wasn't discovered until a hearing in December, that there was Axon video potentially of that. And I don't believe that the state, if the burden is placed on the state, that the burden, that they showed that this was not materially exculpable evidence. And even if the court would find that in fact, okay, it's not materially exculpable, it is in fact potentially useful, and the burden's on Mr. Wilson to show that the state acted in bad faith, I think you can make a compelling argument in this case, because there's an utter lack of urgency on the part of law enforcement, the officers involved, and others to track down this material. They were given ample notice, and if you see from the record, trial counsel made repeated requests for directly Detective Broom's Axon video that was never provided and in fact destroyed. It was destroyed because it wasn't attached to this case, even though there was a supplement in discovery.
Counsel, I'm going to stop you only because you've got 3 minutes. You can continue, but you'll be eating into your rebuttal time.
I will go ahead and
You want to reserve that?
reserve for rebuttal.
All
Thank
right,
you.
thank you. Counsel, of course, you'll have 15 minutes here.
Yes, good morning, Your Honor. May it please the court, Andrea Ruler for the state of Ohio. It's the state's position that given the Axon body camera evidence in this case, it's the state's position that that video evidence is simply not exculpatory. The burden never shifted to the state to show otherwise, and that in the event that there could be said to be a burden shift, that at most evidence, as the trial court indicated, could be potentially useful. However, there's simply been no showing of bad faith in this case.
So do you think the court did address who had the burden of demonstrating whether the video was materially exculpatory? Sorry.
I don't believe that the court specifically addressed that in any of the motions. However, I believe that the law is clear that the burden of establishing that there's been materially exculpatory evidence withheld, that burden is on the defendant.
But what if there's a specific request for videos? Doesn't that shift the burden?
That would shift the burden, absolutely, when there's a specific request. And in this case, as counsel indicated, the first request was 3 or 4 days after the citations in this case and the arrests in this case. And it was a general request, motion to preserve all evidence. And as they got into it, that's where both the W. Bruni and motion, I'm going to mess up my facts here, but Deputy Broomy had complied with that. They had noticed that they were to preserve all the evidence, and actually it would be Sergeant Ellis, since he pursued Mr. Wilson in this case. He did preserve all of the video evidence that he had in Mr. Wilson's case. The issue was that they didn't think to include the video, their body cam footage that they had on their persons while they were out investigating that separate Miller Farm or the Prowler call, because it was unrelated.
Did they ask for all videos from that day, or is it your argument that they should have been specific to say all videos from not only my case, but the case that you were investigating involving a problem?
Yes, it would be that they should have been specific, as that general request was not specific, that it was looking for all videos on those officers on that day. It would, the officers took it as he started, in that cornfield there, but then it was the evidence of I think his actual body cam didn't start until probably he got out of the car, and we probably have dash cam in that Wilson case, or in the Wilson case, but all of that, the only thing that was ever contested here in the motion to suppress even was the, reasonable articulable suspicion for the, traffic stop. There's nothing ever for the rest. There's never any references to how all of this started, and so I don't think that even trial counsel in this case knew that how this started until they got further in, but they still were within that 30-day time frame when trial counsel did then request, I believe it was actually Deputy Broomy's then body cam video, and he did actually, from the Miller Farm call case, and the prosecutor's office called for that. He told them the case number, and the prosecutor's office wasn't able to locate it. And then after that time, because of the way that the videos had been classified, it was after that 30-day time frame.
So at some point in time, there was a determination that the body cam footage, for lack of a better word, at some point that the Prowler investigation terminated and Mr. Wilson's investigation commenced.
Yes.
That's how it was cut off, so it's a continuous video though, right?
I believe it would have been,
Where they
it
turn on
would have
and
had, if they turn on and off, then he would go through the footage there. And that's where, I know that Sergeant Ellis was the one in the cornfield, and he testified at the hearing that he was facing the cornfield, jumped the ditch when he heard a car traveling a high rate of speed, looked over his shoulder, and so he said, from the positioning of his body cam, it would have just been the cornfield, but they had that testimony of what that video would have shown, and he was under oath, in testifying. And then, Deputy Broomy, he had that footage, and I believe he testified that it showed 2 to 3 seconds, of Mr. Wilson's driving. However, he did not preserve that evidence because it was part of the Miller Farm call, the Prowler case, but he was aware that had existed, and he tried to get that to the state. The state wasn't able to access it, and unfortunately by the time they got to everything, that's the video that was missing. However, it's still, even if that would just be merely potentially useful, we really, ultimately it was the OVI, he was arrested for the OVI, and had only challenged the reason for the stop, and then he even actually pled to the high test, which would go more for the OVI arrest. And so we don't have anything here that actually goes towards, his guilt or innocence as to the OVI high test. And so I would say that any of that footage in either of the videos, it really isn't relevant. It's not even really potentially useful. But if we can get to that, sure, maybe is potentially useful, then we can't demonstrate the bad faith, because both officers testified that they were investigating that other call. Nothing came of the call. They put it in the general case file, or the way that they always log and are required to log their reports when nothing comes of it, that they automatically delete after 30 days. And then I think it was when one of the officers realized that the prosecutor's office wanted that video, he notified the prosecutor's office what that case number was so that they could see it in the evidence.com, and when there were the issues, then he went to his captain and he tried to retrieve the video. They both testified that never was it, any bad faith or ill will. They weren't trying to hide anything. It's just, sometimes they didn't see this as being relevant, and sometimes mistakes do happen, and these videos just weren't available. But the end result is the officer's testimony was available, and the mere fact that it contradicts, Mr. Wilson's version of events, that's more for, the trial court to determine. But even in this case, Mr. Wilson ended up basically pleading to the OVI high test in exchange for the OVI to be dismissed. And so overall, he just hasn't shown that there was any kind of a violation to his due process rights. It can't be said that it's merely that it's exculpatory evidence, nor that it's potentially useful, nor that it was in bad faith.
I want to make sure I'm remembering. Did he enter a no contest plea or a guilty plea?
And when I was saying that, I had that Mr. Wilson entered a plea of no contest to the operating the vehicle with the prohibited blood alcohol content. Unfortunately, in my synopsis, I don't cite to. I think overall, I'll just summarize if there are any further questions. Just in the present matter, given that Mr. Wilson entered that plea of no contest, and given, in addition, there were a number of traffic infractions that were visualized by Officer Ellis, or Deputy Sergeant Ellis, as he pursued Mr. Wilson, because not only did the video have that, had the cornfield view, and then he said that he was going to pursue, the speeding and the lane violation arguably would have occurred at that point. But then when Mr. Wilson made a turn, I think it was a left-hand turn onto the road that he lives off of, there was no traffic signal, and then he made another turn into his driveway, without a traffic signal. So when he argued at, the motion to suppress, that it was about no reasonable articulable suspicion for the basis of the stop, that simply isn't true. We have the traffic violations, and that's criminal activity, and all they needed to see in order to go ahead and stop, and then nothing ever was contested as to the OVI arrest. And so we just can't get any further than that. But and as in NASIC, it just cannot be said that the destroyed evidence was exculpatory. The video evidence would not go to the guilt or punishment of Mr. Wilson for the OVI high test violation. It would simply go to a justification for the stop and then subsequent arrest. And so for all those reasons, the state asserts that there was no error by the trial court here.
You got a couple minutes, can I ask you a question? I understand from Mr. Miller, he said that the videos are uploaded to evidence.com.
Yes.
Does the officer actually turn on and turn off the video, or is it a continuous video once he's turned it on?
Yeah, I think that they do turn it on and off throughout, but I can't say for sure what happened in this case. I know they're on a different call, and I know like the dash cam of the car starts with the sirens and everything, and I think it's just they activate their body cam, and so potentially here, the body cam could have been activated still once he drove, but I don't recall seeing that video in this case.
I was just wondering who makes the determination as to when this case ended and this one started, if it's a continuous.
I believe just from the officer's review of and actually the facts here, I believe that it says that that Sergeant Ellis then didn't have his body cam on then once he was pursuing Mr. Wilson in the vehicle. So we don't think that we just have anything from that point forward in this one.
Okay, thank you.
All right, thank you for your argument. Counsel, you'll have 3 minutes that you reserved.
Thank you. Your Honor. Judge, I believe that Sergeant Ellis testified that he did not have the Axon body cam on when he was in pursuit of Mr. Wilson because he was seated and he thought it would just show the
So he jumped
dash of the
in his
vehicle.
vehicle and pursued him?
Correct.
Okay, all right.
Yeah, that's what happened. The only way that someone who's charged with an offense can get the evidence that is be used against them is to make a request. That was done in this case. And then there has to be a reliance upon law enforcement to properly handle that request. If there are things that specifically requested, in this case there was a specific reference that videotapes were to be maintained.
Is that request part of the record?
Yes, it is. That's the motion for protective order that was signed by Judge Milholm in this matter. So that was in fact requested. And then it becomes even more specific because once trial counsel found or received discovery, he had Deputy Broom's supplement, which indicated that he had used his Axon camera, and he starts making requests directly to the prosecutor's office for that videotape. And you'll have to take a look at the record for the exact dates of those, but I believe in one of trial counsel's motions to dismiss, there's a list of and attachments of the requests that he made for Deputy Broom's video. And counsel would not have known to ask for Sergeant Ellis's video because it wasn't disclosed. It wasn't disclosed until during a hearing. Despite having been asked for videotapes, he obviously knew that there was one that wasn't there because he testifies about it at trial. I think the record will show that Sergeant Ellis knew about the protective order. He was served a copy of that protective order. Based on those circumstances, it's our position that, well, first of all, the court may end up sending this back to the trial court to determine who should have been assigned the burden of proof on determining whether or not this evidence was materially exculpable. It's our position that that the burden's been shifted to the state of Ohio because there was a specific request to maintain this evidence, and that the state of Ohio did not do so. And then the burden is on them to show that this was not materially exculpable. And I think it's important for this court to note, too, that we are alleging that this evidence of driving, which would have been the only objective evidence of the driving of Mr. Wilson, did not just go to the reason for the traffic stop, whether that was justified or not. It would have helped with that too, but it also goes to the underlying offenses of driving under the influence and operating with a prohibited breath alcohol content. And there was a no contest plea in this case. Mr. Wilson decided to challenge the rulings on the motion to dismiss in this case, so I don't think he's waived anything by doing that or entering a no contest plea to the operating with prohibited breath alcohol content. That's the only way that he could have gone through a trial if he had chosen to, but he decided it was more effective to ask for a review of this particular ruling.
Counsel, the only thing I'm wondering is, since he pled to the per se violation, you don't have to prove erratic riding or anything because you're above the above the alcohol.
That's correct. You have to show that you have an illegal amount of prohibited substance in your system.
Okay, counsel, thank you. We're a little bit over, but
I apologize.
that's not a problem. Thank you both for your arguments. This morning, the court will take the matter under advisement. We'll issue a decision in due course. The clerk of courts will mail each of you a copy of that decision on the day it's released, and the decisions are also posted on the Supreme Court of Ohio's website.